Hi there, it's Mark Walker here, and I'd like to welcome you to this very special one-off webinar where I'm going to be sharing with you the secrets of how to claim land or property you do not own. However, before I get into that and give you all of the secrets, I'd like to welcome you and thank you so much for taking time out of your busy schedule to come and join me today. It's very important for me to say to you that your time is very precious, and I appreciate and respect that. And so this particular webinar is going to go on for about 45 minutes, during which there will be lots of technical information. But before I get into that, I'd just like you all to give me a little wave, a little hands up, a little yes in the chat box that you can see on the side of the screen, just so I know you can hear me and you can see me. Well, not see me, but see me physically. You can see the slides, and also just let me know where you're from so I can have a little look down that list as we go on during the session. Now, what I would ask is that if you have questions, and there will be lots of questions, please bear with me for one very simple reason. I need to go through the technical side of how to claim land or property you do not own this evening. I will not have time, because I don't want to eat into your precious time, to go through the practicalities of how to actually implement gaining the properties or sourcing the properties, gaining the properties, the legal paperwork, etc., that we have to put in place in order to secure those properties. So what I'm suggesting to you is that if it's okay with you, I will not concentrate too much on the questions in answering them as I go through my technical explanation. But what you can do is, in the chat box, you'll see a little speech bubble, and when you click on that speech bubble, it actually sends a direct question to me, which I will be answering for yourselves. So I will, at the end of the webinar, I will take all of the questions, and then I will come back to everybody so that I can give everybody the same correct information. But in the main, the next 45 minutes will be content filled about the legal side of how I claim land or property that I don't own at the moment in my property business. And we have round about double digits, well, it certainly is double digits of those properties. And what I will also do for everybody is, if it's okay with everyone, this evening, is I will make sure that everybody has an opportunity to come and learn the practical side of what I'm doing in my property business with reference to claiming land and property. But I will do that on a one only group training session. So what I've planned to do is, there is a pop-up which will appear imminently on the screen, and unlike other webinars where I sort of have 5 or 10 spaces in my very small, intimate, successful property training groups, what I'm going to do just for you this evening is to leave that box available, because you may well start understanding when I give you the legal technical side of what we're going to do that it is lawful and it is ethical, and you just want to book yourself on the training day to get the practical face-to-face training notes, as I say, how to source, how to do the paperwork, what paperwork is required, who you talk to, etc. All of that information will be trained to you on the day that we're all together. I do not have the time to eat into your diary today in order to explain everything in full. We'd have a webinar of probably 8 or 9 hours, because that's exactly how much time you will be spending with me on the training day. So you'll find out that the training day has or will appear on the screen, and you'll also find that the date for that training day will also be shown. It is a Saturday, and it will be held at my private business luncheon club in the centre of Birmingham. And the reason for that is it's easily accessible from the M5, the M1, the M6. It's a 2-minute walk from Snow Hill Station in the middle of Birmingham. It's a 6-minute walk from New Street Station. So it's very central for everybody from all over the UK to come and visit me in my private luncheon club. You'll also get to see exactly what we do behind these closed doors at these luncheon clubs. Lots of business contacts, and very famous business contacts are members of my particular club in Birmingham, and I'm a member of clubs all over the country, and indeed reciprocal club agreements all over the world. So I really can connect you guys with other business people, as well as sharing exactly how I've been successful now in property for well over 25 years, and of course having been in business, well, pretty much for 40 years, but I won't go into what my first business was when I was 8. For those of you who have followed me for long enough, you'll know my life's journey. So without further ado, I'm going to go straight into the presentation. Now, get your notepad ready. Hopefully you've already done that because this is a live webinar. So get your notepad ready and make sure all those distractions are turned off. Make sure your phone's turned upside down and it's switched off. There's no point in listening to the webinar if you're going to be disturbed, because this is a one-off training and it's going to share with you, as I say, the technical side of how or why as well, how and why you can claim land and property you do not own here in the UK completely ethically and completely legally. So I am going to go through all of my slides for you to read at the same time, one by one, and I will catch you at the end of the webinar. So, how to claim land or property you do not own, presented by myself. This is a live webinar training on adverse possession of registered land in the UK. A guide to adverse possession of registered land under the Land Registration Act 2002. What is the doctrine of adverse possession as described in the Law Commission Report 271, which for the duration of this webinar I'll be abbreviating to LawCom. Well, land registration for the 21st century, or LawCom 271, allows the acquisition of a title to land owned by someone else by continually possessing and using the land for a set period of time without the permission of the owner. One of the grounds for the doctrine set out in LawCom 271 is that land is a precious resource and should be kept in use. But LawCom 271 also recognised that in the doctrine of adverse possession, the balance between landowner and squatter needs to be adjusted to overcome some of the deficiencies while maintaining the advantages. LawCom 271 set out the terms of and a commentary on a land registration bill that would become the Land Registration Act 2002, also known to us as LRA 2002. Prior to the coming into force of the LRA 2002 on the 13th of October 2003, adverse possession claims in relation to both registered and unregistered land were subject to the Limitation Act 1980, or LA 1980, and the acts required to support a claim of adverse possession were explained by reference to case law. Thus, in order to establish a claim to have acquired a title by way of adverse possession, the applicant or squatter must have demonstrated A. factual possession of the land without the owner's consent, and B. sufficient intention to possess the land, such as by acts of use or maintenance, and C. all of the above for a continuous 12-year period, longer in relation to certain types of land or owners of land. All of this criteria applies even in other circumstances. For example, where the land concerned is unregistered or, as will be mentioned later, in additional options. By the way, I did say it's quite technical, so I hope you're making notes and sticking with me. If you want to jump straight to the end, my friends, and just book that day with me, you'll see that you will get all of the practical side of the training. But I have to go through the technical side, as I say, this evening, so you can understand that it is absolutely ethical and lawful to conduct adverse possession, including bona vacantia, in the UK. Okay, so you can click that now and secure your seat. There are a limited number of seats, and I will only allow the shopping cart to remain at the other end of the button that you can see in front of you. As soon as all those seats are filled, as I say, at my private business club, that will be it. That will be the end of the training and the end of the adverse possession training, certainly for the foreseeable future. Okay, just wanted to drop that in because exactly how I'm talking to you now with all the technical information, hopefully you're making lots of notes. You should be making lots of notes, because just think of all these pieces of land around the UK and empty buildings I'm going to show you how to claim at no cost. It's a phenomenal property investors strategy tool, which not many of you will be using now. If you are, then please train me and show me how you're getting them. But as it is, I've done this for 25 years and I'm going to teach you exactly how to do it on the day. So let's jump straight back into the technical side and I'll continue with the slide for you. So the purpose of this training, however, is solely to deal with the new adverse possession of registered land ADV1 regime introduced by the LRA 2002. Please refer to Practice Guide 5, which is available on the Land Registry website, for further information on the practice and procedures of land registry in relation to applications for title based on adverse possession of unregistered land or under additional options, LRA 2002, the ADV1 procedure. Now, just jumping back out of this for a second, I will be sharing all of that information with you about the practical guide, etc., on the day when we meet. So Section 96 of the LRA 2002 disapplied sections 15, 16 and 17 of the Land Act 1980 and introduced an entirely new system of applications for adverse possession of registered land. The new system required the acts or factual possession and intention to possess of adverse possession, still explained by reference to case law, to have been carried out for a period of at least 10 years, longer in relation to certain types of land, such as Crown foreshore, to entitle the applicant to apply to be registered as proprietor of the registered estate in place of the current proprietor. The relevant application form is ADV1. The form must be accompanied by a statutory declaration or statement of truth made by the applicant not more than 1 month before the application is lodged, together with any other relevant supporting evidence to substantiate the claim of adverse possession. A form ST1 may be completed for the statement of truth and is a useful guide as to the other information needed, for example by Rule 188, Land Registration Rules 2003, and Rule 215A of the LRR 2003. In the case of the first application, an applicant must show that they and any relevant predecessors in title have been in adverse possession for at least 10 years, ending on the date of the application. The applicant does not have to be in adverse possession personally for the entire requisite period, provided they are a successor in title to a previous applicant. For example, if A is in adverse possession for 5 years, then transfers their interest to B, who continues in adverse possession for a further 5 years, so the 10-year period is continuous, B is entitled to apply using a statement of truth from A and B for the total period. Now can you see how you can make some money here, my friends? However, if B evicted A, then B would not be entitled to apply at the end of their 5 years. An application made on this basis should confirm how title has passed between the applicants and preferably include any documents purporting to transfer the interest. If the applicant has been in possession for 10 years but is then evicted, then provided the eviction was not pursuant to a court order for possession, it still may be possible for the applicant to make an application. Any such application must be made within 6 months of the eviction, and at the date of the eviction the applicant must otherwise have been entitled to apply to be registered. Even where an applicant has been in adverse possession for a 10-year period and otherwise fulfills the criteria, the LRA 2002 prescribes 4 circumstances where no application may be made. These are as follows. Where the applicant is a defendant in proceedings involving possession of the land, that is, the applicant can't make an application for adverse possession where they are defending eviction proceedings. Where a judgment for possession has actually been given against the applicant in the last 2 years. During any period where the registered proprietor is an enemy under the limitation, that's Enemies and War Prisoners Act 1945, or is detained within enemy territory, or 12 months following the end of such period. See, it does get quite dramatic, my friends, this whole adverse possession. And as I say, this is quite technical this evening, so please make sure if you want to come onto the practical day that you click that button and secure your seat now. There are a few seats that have already been secured, and I appreciate a few people have emailed to say that they have to jump off the webinar because they have things to do, but they're already locked themselves in for that special day. So if the technical side is starting to make your head buzz, then please just secure that day and you'll get the absolute practical version of what I'm explaining is the law to you this evening, so that you can understand that what I'm going to train you on that day is absolutely above board and legal. And the fourth reason is where the registered proprietor has a mental or physical impairment which adversely affects their decision making or communication ability. It is important when completing their application that the applicant considers what their position will be if the registered proprietor serves a counter notice to the application, requiring the land registrar or the registrar to deal with the application under paragraph 5 of Schedule 6 to the LRA 2002. If a counter notice is served, then the applicant is entitled to be registered only if any of the 3 conditions set out in paragraph 5 are met. We consider these conditions further on. The applicant needs to identify if they wish to rely on one or more of the conditions in the ADV1 and ensure the statutory declaration of ST1 sets out the relevant facts in support of this. If, upon receipt of a valid application, the registrar decides from the evidence supplied that it is more likely than not the applicant is entitled to apply for title based on claimed adverse possession, then notices will be served. As part of this decision-making process, the registrar may commission an inspection report from an Ordnance Survey surveyor to provide further information. Paragraph 2 of Schedule 6 to the LRA 2002 specifies certain parties that notice of an ADV... Sorry, I'll rephrase that. Paragraph 2 of Schedule 6 to the LRA 2002 specifies certain parties that notice of an ADV1 application must be served upon. These parties will have the opportunity to object and or serve counter notice within a 65 business day notice period. If no objection is received and no counter notice is served, the applicant will be registered in place of the registered proprietor. Now again, just to pause there for a second, you can see that the technical side, the law side, is quite intense, and I truly believe that's what puts a lot of individuals off. That they look at this, they try and read and understand what I'm explaining this evening, and it really just makes the brain fuzz and they walk away from it. However, on the training day, as I say, which is March the 25th, starting at 9 a.m. in the morning, you will have an opportunity to have me go through cut through the wheat and chaff of all of the legalities that we're talking about today, and share with you the practical side of how you do exactly what I'm doing in my property business week on week. So be sure to click that button and secure your seat now. And if you have to then jump off this particular webinar, I look forward to seeing you on the morning of March the 25th. But other than that, let's move on with some more of the slides. The Land Registry may also, at its discretion, serve notice of an ADV1 application on additional parties not specified in paragraph 2. However, these parties will have the opportunity only to object to an application and must do so within a 15 business day notice period. In the event, the registrar is required to deal with the application pursuant to the provisions of paragraph 5. Then, in order for the application to proceed, the applicant will need to demonstrate an arguable case that at least one of the 3 conditions set out in paragraph 5 has been met. The first condition, proprietary estoppel, which is paragraph 5, section 2. This condition is based on the principle of proprietary estoppel. The applicant must show it will be unconscionable because of an equity by estoppel for the registered proprietor to attempt to dispossess the applicant, and the applicant ought to be registered as proprietor. Again, just to pause, this whole UK land issue is all about proprietorship and ownership, and we as property investors are looking to control that property or land. One of the things I cover on that morning when I'll be seeing you on the training day is how land was originally grabbed and who grabbed it and how they were able to carve it up, and have you believe that today when you own a property you actually own everything around that property. And of course, for those who are in the know, namely here today myself, then I know that you may own the bricks and mortar, but you certainly do not own the land that even comes with your house or your business premises. So it's very important. On the March the 25th, I will be going into the ins and outs of land, how it was acquired, and what it means for you as a property investor, and how you can benefit from understanding this adverse possession and bono vacantia legislation in order to grow your property business without having to ever own those properties or land in the first place. The applicant will need to evidence the claim that the proprietor's actions incited or encouraged the applicant to believe they own the land, that the applicant acted to their detriment to the knowledge of the proprietor, and that as a result it will be unconscionable for the proprietor to deny the applicant their rights. Law Commission 271 sets out 2 examples of where this condition may be applicable. Where the applicant has built on the registered proprietor's land in the mistaken belief they were the owner of it, and the proprietor has knowingly acquiesced in their mistake. The applicant eventually discovers the true facts and applies to be registered after 10 years. When neighbours have entered into an informal sale agreement for valuable consideration by which one agrees to sell the land to the other, the buyer pays the price, takes possession of the land and treats it as their own. No steps are taken to perfect their title, and there was no contract. If the applicant has been in possession of it for 10 years, they can apply to be registered as proprietor. The second condition, squatter, has some other right to the land. paragraph 5, subsection 3. The examples given in Law Com 271 are that the applicant is entitled under the will or intestacy of the deceased proprietor, or that the applicant contracted to buy the land and paid the purchase price, but the legal estate was never transferred to him. The applicant is a beneficiary under a bare trust, and so can still be in adverse possession. So again, just pausing there, it's about trust, not the trust that you and I will understand, that we trust somebody we know, like, and we trust them. We're on about the trusts and the legislation surrounding trusts and how they're used to control certain parts of legislation, and how we can utilise, once we understand the practical side, which, as I say, I'll be teaching you on March the 25th, to take control of land and property you do not own. Now, the third condition is mistaken belief as to the boundary, which is paragraph 5, subsection 4. This ground may be relied upon where the applicant has been in adverse possession of land abutting their own under the mistaken but reasonable belief they owned it. There must have been no determination of the relevant boundary pursuant to section 60 of the LRA 2002, and the land the subject of the application must have been registered for at least 1 year prior to the date of the application. Response to notice. When serving notice of an ADV1 application, and I'll go through with you on the training day exactly how we fill these forms in, on any of the parties set out in paragraph 2, Land Registry will include a form, NAP, for recipients to use when responding to us. A recipient of a notice has the following options: consent to the application, not respond to the notice, object to the application, and serve a counter notice. Not responding to a notice will be treated the same as if the recipient had consented to the application, and a recipient may both object and serve counter notice should they wish. Again, very interesting that by submitting a notice, if an individual has not replied to that notice, it will be treated the same as if the recipient had consented to the application. And this goes for so many different rules, regulations, laws, legislature in the UK, which I will be sharing with you on the training day. How you can serve notice for certain elements within your property business, and if someone decides to ignore it, that's fine, but actually you are completely covered because it will be treated as though they have consented to that application or notice. So a very interesting point of law that I absolutely adore these elements of the law, and how I can assist your business and your property journey by utilising to the fullest extent. Back to the slides. So, consent given or no response. Land Registry will proceed with the application, registering the applicant as the proprietor of the land in place of the current registered proprietor. Objection made. Section 73 of the LRA 2002 gives anyone the right to object to an application, so anybody, whether the recipient of notice or not, may object to an ADV1 application. However, only a party specified in paragraph 2 can serve counter notice. All objections must comply with the requirements of Rules 19 and 198, Land Registration Rules 2003, before they can be considered. Objections will usually challenge the applicant's claimed acts of adverse possession of the land, or the period of time over which they have been carried out. However, all objections are considered on their individual merits when received. If an objection is considered groundless, then it will not affect the application. However, if it is considered non-groundless, then notice of the objection will be served on the applicant and the dispute process will commence. If no agreement is reached between the applicant and objector, then disputed applications will be transferred to the Land Registration Division of the Property Chamber, First Tier Tribunal, for judicial resolution. Again, this whole process is ethical and lawful. Just think for one moment, would there be all of these rules, regulations, property chambers, first tier tribunals for judicial resolution, all in place by the government and the court system and the land registry departments if you are not able to claim land and property that you do not own? But again, on March the 25th, I will cut through all of this legalese and we'll get straight down to the practical side of what you have to do, how you do it, and how you secure that land and property that's in your local area. For more information regarding disputes procedure and potential cost consequences, take a look at Practice Guide 37 and Practice Guide 38. Again, I'll be sharing those with you on the training day. Counter notice served. If just a counter notice is served, the registrar will then consider whether the applicant is relying on any of the three conditions set out in paragraph 5. If the applicant is not claiming in their application to rely on any of the three conditions, the application will be rejected. If the application is relying on one of the three conditions in their application, then the registrar will consider whether or not the evidence submitted shows an arguable case for the relevant conditions being met. If the registrar is satisfied an arguable case has been made out, the party who served the counter notice will be contacted. They will then be given the opportunity to object to the application on this ground. If the objection is non-groundless and no agreement is reached between the parties, the matter will be referred to the tribunal. If no counter notice is served, then paragraph 5 conditions would not form part of Land Registry's reasoning when deciding whether an applicant is in adverse possession of the land. When an application is rejected, the applicant will be able to reapply to be registered as proprietor 2 years after the date of rejection under paragraph 6 of Schedule 6 LRA 2002, provided they have remained in adverse possession of the land. So even if your application is rejected, you can reapply after 2 years under paragraph 6 of Schedule 6 of the LRA 2002, provided they remain, or you remain, in adverse possession of the land. Of course, land can also be property. Do you see where this is now leading, my friends? Do you see how excited I am when I go out, going and doing what I need to do to secure the land and the property that I have in the areas that I choose to target? This is very powerful legislation. And again, on March the 25th, click that button and secure your seat so I can share with you the paperwork, the processes and the strategies, and share with you those properties that I have secured and am securing under this legislation, which is there waiting for you. It's like a gold mine in your area. And I'm saying, look, click on that button, pick up that pickaxe and go and hack into this rock and start digging your gold, because it's absolutely essential to have a practical understanding of what you need to do. But again, I trust you appreciate, some 30 minutes now into the webinar that I really need to go through this legalese with you so you understand that it is above board, it's ethical, and it's possible to continue with adverse possession and bono vacantia. So let's move on again with the slides. Remember as well, you can keep putting those questions into the chat box. I see that there's quite a lot of communication going on, and I will answer every single question personally back to you with absolutely no problem at all. But let me crack on with these slides because I'm mindful of your time. If both a counter notice and objection is received in response to the initial notice served by the registrar, the objection will be dealt with first, as referred to above, unless it is withdrawn. Unusual applications, trust issues. A person is not to be regarded as being in adverse possession of an estate when the estate is subject to a trust, unless the interest of each of the beneficiaries in the estate is an interest in possession. For example, where land is held by the registered proprietor, P, on trust for B for life, adverse possession cannot begin until B became entitled in possession. This provision is designed to protect the interests of beneficiaries not in possession. Applications for adverse possession of registered leasehold land. When an applicant takes possession of land subject to a lease, then the time period required is deemed to run against the tenant but not the landlord. Time does not begin running against the landlord until the expiry of the lease, unless the applicant went into possession before the lease was created. The applicant's position is also confused by the possibility that the tenant can apply to surrender their lease at any point. On the face of it, once the leasehold title is surrendered, any time in adverse possession built up by the applicant is also extinguished. However, it has been suggested that the decision in Central London Commercial Estates Limited versus Kato Kagaku in 1984, that's ER 948. That is the case law that you could go and copy. Write that down and go and copy that into Google and just go and have a read of the case law. Decided under the Land Registration Act 1925 allows an applicant to apply to alter the register by reopening the closed leasehold title and making an ADV1 application against this reopened title. The applicant's right to make an application under paragraph 1 of Schedule 6 LRA 2002 would need to have arisen before the leasehold title was surrendered. So can you see there that you can actually have leasehold properties and take control of leasehold properties where the lease has run out? And this is very useful in one particular strategy that I will teach you on our day of training, which will be quite easy to implement, certainly easy to find those particular properties in your area, but very easy to take control of land and property where the lease has actually expired, and linking in with a few previous slides ago, potentially where the deceased estate is just, it's not even in probate, you know, it's just a deceased estate with nobody else, no other family members around. So that gives you an opportunity to reinstate a number of items. Again, I'll go for the practical things on March the 25th with you. Onto the slides. Encroachment onto registered land from leasehold land. A specific issue arises where an application is made by either the landlord or tenant of a property to be registered as proprietor of adjoining freehold registered land by way of adverse possession. This issue centres around the presumption explained in the case of Smirk vs Lindale Development Limited 1975 1 CH317 that a tenant who encroaches onto land does so for the benefit of their landlord as an accretion to the lease, or the presumption of. An application by a landlord in relation to encroachments on the part of their tenant falls within the presumption, and so the applicant can proceed assuming the tenant's acts of user are satisfactory. There is some debate as to whether the presumption applies to such an application lodged by a tenant. See section 11.2 of Practice Guide 4. One view is that the tenant will be required to rebut the presumption. However, there is a competing view that the presumption is concerned only with who might have acquired title at common law to the estate and does not alter the fact that the tenant is in adverse possession, rendering it irrelevant where the application is made under Schedule 6 LRA 2002. And here we are again, my friends, talking about common law to the estate. So many people, so many even experts and professional property investors forget that, you know, common law in this land supersedes even legislative law. And again, on the day when we meet on the 25th of March, I will go through exactly how we can use common law in our business to better ourselves and move ourselves forward completely ethically and lawfully. Now, it is likely that the mere act of submitting the application in their own name will be sufficient evidence the tenant intended their encroachment to be for their own benefit, and so the above distinction is largely academic. Due to the likelihood that both landlord and tenants may have an arguable claim to the adversely possessed land, notice of an application will be served on the other. Notice will also be served on the registered proprietor of the land, which may also be the landlord. Additional options. Remember, I mentioned earlier in our slides there are some additional options to take into consideration. Aside from the ADV1 procedure set out in this article and training, applications for adverse possession in relation to registered land may also be made under the following circumstances. Under the transitional provisions set out in paragraph 18 of Schedule 12 of the LRA 2002, where an applicant can demonstrate that the land was registered as at the 13th of October 2003 and there had been adverse possession for the appropriate limitation period by that date, then the registered proprietor would be deemed to hold the land on trust for the applicant, who would be entitled to be registered as the new owner. Where an applicant can demonstrate the documentary title to registered land was already defeated by adverse possession before first registration, it is possible to apply to alter that registration on the grounds of error to deregister the land concerned. Again, it's all about registration and deregistration and possession and controlling and making use of. Yeah, so these are some of the points, and I hope you get really excited at your end. As I say, I get so excited about adverse possession. It really is a minefield of legislature, but when we meet up on March the 25th, I'm going to cut through all of this and just show you exactly what you need to do and what paperwork you need to use, and send you on your merry way, my friends, back to your local areas where you can start cleaning up because you now understand how to take control of land and property you do not own. This is a two-stage process, as if the alteration is successful, then a fresh application for first registration of the applicant's claimed adverse possession title is also needed. Where an applicant's adverse possession is such that they may apply either under the ADV1 procedure or the transitional provisions. Both applications may be lodged at the same time, but one will be held in reserve until the other is either completed, cancelled, or rejected. The applicant must decide which application is to be processed first. The ADV1 procedure and transitional provisions differ in when title is deemed to have passed to the applicant. Under the transitional provisions, as with unregistered land, the paper title is deemed to have been extinguished as soon as the applicant has been in adverse possession for 12 years. However, under the ADV1 procedure, the applicant's 10 years of adverse possession does not automatically extinguish the paper title. Instead, it merely allows the applicant to apply to be registered, but this application can still be defeated if counter notice is served and the applicant cannot satisfy any of the conditions set out in paragraph 5. Therefore, title under the ADV1 procedure does not appear to pass to the applicant until the application is completed by registration. Key points. 1. When preparing an application, it is important care is taken when deciding which of the paragraph 5 conditions are to be relied on. The supporting statement of truth or statutory declaration should include information regarding the applicant's reliance on the chosen paragraphs. An applicant may rely upon more than one of paragraph 5 conditions in making their application. If an applicant does not rely upon any of the paragraph 5 conditions or does not satisfy the conditions they have relied upon, then the application will fail. Should the recipient of notice serve counter notice. You see how this gets me? This is the legalese I have to go through just to show you that this is credible and lawful is incredible. But on the training day, as I say, we'll wipe all of this out and we'll just get straight down to the practicality. If no counter notice is served, then the reliance or not on paragraph 5 conditions becomes irrelevant. Number 2, it is important to note that the basic principles of adverse possession that the applicant must demonstrate factual possession and an intention to possess the land without the true owner's consent for a period of years remain unchanged by the LRA 2002. Let's go through that again. Factual possession and an intention to possess the land without the true owner's consent for a period of years remain unchanged by the LRA 2002. Again, do you see where I'm coming from? How powerful, my friends, this strategy in your property business is. Number 3, it can be seen from the above that the effect of not receiving a notice and therefore not being in a position to serve a counter notice or lodge an objection is far-reaching. It is clearly critical that registered proprietors keep their address for service up to date with Land Registry. This training does not replace the need to consider Practice Guide 4 before making any ADV1 application. And you know, for today, it's absolutely the end of what I have to share with you. 2 reasons. One is we're nearly at 45 minutes coming up. And just before I move on to the next slide, I want to explain that that was really technical. And I know a few people have dropped off this webinar. However, contemplate this for a moment. You now have the basic information to make an informed decision about whether to take the training with me on March the 25th. Quite a number of seats have already been secured, and the one thing you'll notice I've not done is I've not mentioned the price for that training day. I've told you the venue and the date and the time that we'll be starting, but I've not mentioned the price. And there's a very good reason for that, because this land and property training is priceless. You will be able to go back to your local area and secure land and property you do not own, which could be worth hundreds of thousands or millions of pounds. And it was very important that I did not talk to you today about the cost of coming and training with me, because it isn't a cost. It's like the time that you're investing here today. It's an investment into your education. Now, for those of you who have followed me for some time, you'll know what my monthly mentoring charges and rates are, and I'm not upselling you to those this evening, but you will know that I charge a considerable 4-figure sum for monthly one-to-one mentoring. When I am able to get a group of individuals, like-minded individuals who are looking to educate themselves more and get you all into a room basically, I'm able to bring down that cost, of course, because it divides into the room easily. But this very special training is going to lead me to make an offer now that I do not do, certainly on social media. You won't see this offer going out to the general public in terms of an advertised price. But the cost to me to invest my whole day and the information that I will share with you, that practical training, the information of showing you the properties that I currently hold under adverse possession, the investment for you to come along on March the 25th will be held for another few moments, okay? And there's a reason for that. Because what I'd like to share with you now are the names of the individuals and their positions who helped in the actual creation of this webinar information for you. And the next slide shows it was created and constructed with thanks and input from Assistant Land Registrars Chris Day and Charlotte Takuchi. So big thanks to Chris and Charlotte for putting a lot of this information together. The legalese aspect, of course, rather than the practicalities. They won't be coming along on the day for the training. The training will be myself, as I say, cutting through all of the legalese information and sharing the practical side of what you have to do. So it just leaves me to thank you so much for joining me on the webinar. It's been a guide to claim land or property you do not own, which is adverse possession of registered land in the UK. And of course, it was presented by myself. Now, you may be asking yourself, Mark, where do I go from here? Well, for yourselves, this is where the magic happens. Because on a practical side, what I need you to do is to come and learn from me, excuse me, on March the 25th. We'll start at 9 a.m. in the morning. It'll be held, as I say, at my business luncheon club, the private business club right in the heart of Birmingham. It's, as I've said earlier, just 2 minutes away from Snow Hill Station, 6 minutes away from New Street Station. There's national car parks, 30-second walk away, accessible from the M5, the M6 and from the M1. So anyone from Glasgow right the way down to London can come and join me on Saturday, March the 25th. But the magic happens when you turn up on the day and you take that practical training. And so as I wrap up here, all I ask you to do is consider and make an informed decision about whether you are going to take the 45 minutes that you've invested in yourself time-wise this evening and convert that into paying just £197 to come and have a full day of training with me on adverse possession and bono vacantia. Or are you going to take the 45 minutes that you've just invested, take the notes that you've done, close your notepad and stick it on the shelf and allow it to become additional shelf development? I want you to have some self-development. I'd love you to come along on March the 25th. I'd love you to come and join me, because not only on the training day do we get to know, like and trust each other even more, you'll get to have all the practical experience where you can then take on board everything that this legalese training has taught you about the fact it's completely ethical, completely above board, it is possible, it is doable, and it is doable because I've been doing it for many, many years, but it's doable for yourself. And I will show you on the day how to take all of the legalistic jargon that you've just learnt in the last 45 minutes and actually convert it into what you want in your property business, which is land and property you do not own. Now, bearing in mind that adverse possession and bono vacantia are two tools in my toolbox that I use as a professional expert property investor. I have a number of different tools in my toolbox, but this is the only one that I use to claim land and property that I do not own, that I stumble across in my day-to-day. So this is the training that I'll be sharing with you on that day. Is when you're out there doing things, you will come across different pieces of land and different properties that you do not own, that possibly, and in fact practically talking to most people in my career, when they come across them, they walk away from them, or they'll assume that somebody else is doing something with that property. And I can tell you guys and girls that that is not the case. Too many people in the property investor industry, including individuals or newbies as we call them, new people coming into the industry, look at something that might be overgrown and assume that actually it's somebody else's, that somebody else is doing something with it. And you will be absolutely blown away on March the 25th by the information that I share and using live examples from your area. So I'm going to do practical exercises and look at the area where you're from and show you land and property that you will be able to go back and attempt to claim under this training of adverse possession and bono vacantia. And of course you will have all of the documentation given to you in terms of the information and the pages and the reference documents you need to use and secure in order to gain those particular properties through this strategy. So 45 minutes has just gone by. I'd like to thank you so much again for joining me on this very, very special webinar. I am Mark Walker, the Business Builder. I look forward to you clicking on that link that you can see on the page to secure your seat. As I say, quite a number of seats have already gone. This is not a room I'm going to have 60, 70 people in. So as soon as you click on that button to secure your seat for just £197, as soon as the limit is reached within the software, you will no longer be able to book your seat. Go and click on it now. Go and secure that link. Come and meet me. Spend a good 8 to 9 hours with me. We don't do any, by the way, just in case you're wondering about content, I'm not a guy that does, morning breakfast breaks for an hour, afternoon tea and coffee breaks for an hour. We take a short lunch break in the middle of the day, but that is it. You will get solid content for those hours. And at £197, if you don't secure this, you are going to miss out on millions and millions of pounds worth of potential property and land deals in your area. Look forward to seeing you, guys and girls. Thank you so much for your time today. I wish you an awesome, awesome week ahead, and thank you so much again for joining me. I look forward to seeing you on March the 25th. Thank you so much and goodbye.